Welcome to our January START webinar on legal updates in school transportation. We will be getting started shortly. We have a fairly large audience for this, and we're going to give folks a chance to sign in. And so just stand by. Everybody is on mute. What I would appreciate is if someone could send me a quick chat to let me know that they can hear me, that I'm coming through loud and clear. Thanks, Dave. All right, so at least I don't have to worry about that. I know you guys can all hear me. Thanks, Sharon. Hi, Sharon. Appreciate you all signing on. Just sort of stand by, and we're going to try to get started as close to 10 o'clock as we can. We may wait a couple of minutes after, because like I said, it's usually a log jam to get people signed in. So, but we know time is precious for all of you. So stand by, and we'll be back. If any of you do need to contact or communicate, you can either use the chat function or the question function in the meantime. But just stand by, and we'll get started shortly. Rich and Christina, are you on?
I am.
Yeah, I'm here. Yeah, I just muted my phone because
Okay,
I don't want you to get all that background from the girl.
No problem. From the crowd. That's fine, Christina.
I'm going back on mute now, just so you know.
Okay. Once again, good morning, everybody. It is 10 o'clock. We're going to wait about 5 more minutes because people are still still logging in. So just stand by. We welcome you all to the webinar, and we will get started. I think we'll go for a 10:05 start, Rich, if that's okay with you.
Yep, whatever works for you, Mike.
Okay. I think that should be good. We've got them all signing on right now.
We had a great PSBA meeting there just that passed. That was good stuff, Mike. We're looking forward to seeing lots of people at the bus-in Washington, D.C. coming up.
Oh, that's super. Excellent. Yep. And we've got our lobby day coming up in March. So that'll be a good
fantastic.
A good way to set the tone even for that, because the bus-in's in April, right?
Yeah, bus-in's in April. So I guess the next big advocacy again is going to be Harrisburg. Looking forward to that one as well. It's always well attended.
Yep. Let's see. Oh, they're starting to fill up. This is good. Once again, I know we're starting to fill up pretty quick here. For anyone just signing on, we welcome you to the webinar. We ask that you just sort of stand by, and we will get started at 5 after. We're just going to give everyone a little more time to log in. Yeah, Rich, I'm hoping in Harrisburg we can do less, we can do a little more education of legislators and informing them rather than having to play defense. We're hoping the governor's budget leaves us alone again.
Yeah, that would
be nice.
That would be especially nice, because I think that when you get their ear and you can tell them an affirmative story instead of playing defense, it's always an easier sell too.
Oh, absolutely, absolutely. So that's what we're kind of keeping our fingers crossed. We'll see. His budget address is, I believe, February 4th. So
we'll know more then.
Yeah. Kim usually gets a little bit of detail in advance, a little bit of it. So again, I'll be repetitive, but people are just starting to sign on rather rapidly. We're getting pretty close to 5 after. We're going to start at that time. Welcome everybody. Everyone is on mute, and so we do that because of the amazing amount of background noise we get when we have this many folks on a webinar. So just stand by. In another minute, we'll get the festivities started, and so we can get to the presentation. So just hang in there for one more minute, and we're going to give a few more people a chance to sign on. Okay. We are at 5 after, Rich, and I think what we'll do is by the time we keep getting through our introductions and everything else, we should be ready to go.
Sounds good.
So good morning, everybody, and welcome to our first START webinar of the new year. We wish everyone a happy new year. Today we have with us Rich Kelly, who'll be presenting legal updates in student transportation. Just a few reminders. Everyone is on mute. So you can hear me, I can't hear you, and we do that again because of the amount of background noise that we tend to get when we have this many people on the line. This webinar is being recorded and will be posted. A link will be posted to it in the member-only section of the website. If you don't have the information to access the members only, if your company has not done so, or you can't find your information, you can certainly send me an email or follow up with me after the meeting, and we'll help you with that. For questions and answers, again, because of just having everyone on mute to keep, if you have any questions, feel free to forward them using the question function, the question tool that we have in GoToWebinar. And we've done this before. Rich has done many webinars for us, so Rich and I work pretty well together on this kind of stuff, and I'll remind him, or he'll pause and ask me for questions if we have any. And then real quick commercials, upcoming webinars. In February 20th, we have a workers' comp webinar coming up. More information will be out probably early next week on that. April 16th, we have a topic on special needs that'll be happening, and that's going to be a topic will be announced shortly. And then in May, on May 14th, Grace Kelly will be joining us for a webinar on workplace investigation. So we got a great lineup, and we're probably going to have a March webinar as well. And so just keep watching the newsletter and the webpage, et cetera, for all of that. So we're going to move on. Today's presenter is not a stranger to our webinars or regional meetings or conventions, and that's Rich Kelly. Rich is the founding member of R.C. Kelly Law Associates, which is a practice focused on helping commercial operations grow and improve. He developed the firm's business counsel program and contract administration program in response to the unique needs of small and growing businesses that he encountered through working through the insurance industry, through their agents and commercial policyholders. Rich is our go-to legal person when on school bus issues. He has helped numerous contractors across the Commonwealth with various issues. We are very, very happy to have him again with us today. So I'm going to turn this over to Rich. And Rich, we welcome you, and thanks again for presenting this morning.
Thanks for the opportunity to talk with everybody. I really appreciate that, and really appreciate we've got a lot of people signed up, and I can see on the screen today. So I'll try to get started here and let you know that this is something that we do on an ongoing basis. So usually January we do legal updates not only for PSBA but for a lot of state school bus associations and the national. It is a broad review of the evolving laws, regulations, decisions, legal trends that affect the school bus contractors in Pennsylvania and across the country. And so to kind of understand what is motivating some of these things, I think it's always useful to take a look at the current school bus industry environment, because current events and recent events seem to really drive legislation, regulation, court opinions, things of that sort. So the relevant current events are, as everybody knows, increased legislative, regulatory, industry, and public push for school bus safety. I mean, it's always been a focus, but I think the drumbeat gets louder and louder as we go forward. Of specific note, some of the national school bus organizations, like NASDIPS, the National Association of School Directors for Public Transportation or Pupil Transportation, and also NAPT, that's the school district side, the National Association for Pupil Transportation, are actively advocating for school bus safety technology to be mandated at the federal level. And this is a change from previous years. Those organizations had previously been, I'll say, neutral and not so active in Washington and in advocacy circles. But in 2019, they've really kind of moved to a more aggressive stance on that. In fact, NAPT has put forth an initiative they call Zero Zip Not a None, and it's about eliminating completely student fatalities on school buses by the year 2025. So with that, they've become strong advocates. That's not a bad thing, but I think that it is a notable change that we should be aware of. Now, the National Highway Traffic Safety Administration continues to recommend against the need for seatbelts in school buses. They have done research and studies, and they believe that compartmentalization does provide adequate protection, and they have studies to prove that. But the reason they're on the screen is that their position is often misrepresented in news and in media. Now, the National Traffic Safety Bureau, NTSB, is a strong advocate, but the important difference here is NHTSA is the regulatory body that actually makes traffic laws. NTSB is the advisory government body that investigates crashes and makes recommendations. They are not a lawmaking body, but they are a vocal and influential advocate for seatbelts and for safety technology on school buses. Now, an important difference between the two, NHTSA has advisory committees, and there are school bus participants on those committees and traffic participants, things of that sort. NTSB, their advisory committee, their board, is largely made up of aviation professionals. And as you know, aviation is much, much different from not only school bus, but also from just highway traffic to begin with. But again, that's a background that we're dealing with right now. The Stop for School Buses Act is the passing law that's being advanced at the federal level by Walorski, and that does continue to gain support. And again, the reason I put that up there is, as we know in the school bus industry, the danger zone around the bus is a far more perilous place for students than inside the bus. The majority of student fatalities and student injuries related to school bus transportation is around the bus and from illegal passing, not from inside the bus. Some of the other relevant current events, there is rising interest in what I call rideshare programs. And those rideshare programs take typically two models. There's what I call the Uber/Lyft model, where the driver owns the car and the driver is an independent contractor that works for a company like Uber or Lyft. The second model that a few of them follow out there is what I call the contractor model. And this is a situation where these one-off companies providing on-demand student transportation actually own the vehicles, and they actually hire the drivers as employees. One of the ones I've heard of is Hop, Skip, Ride. There's a couple of others. I met them demonstrating tables, have booth tables at the NAPT conference, and they're becoming more and more common. So we're watching that activity. And this last one, the increasing frequency of RFPs or demands of concessions, is happening everywhere, but it is especially prevalent in Pennsylvania. And I think that really makes contractors need to look at the viability of the long-term contracts that have been renewed by agreement. It's increasingly challenging, especially for smaller contractors. We'll talk a little bit more about that, but very often the concessions that you're being asked to make are they may not have a dollar amount attached to them, but in the long run they're going to cost you money. They may ask for a level year instead of an increase. They may ask for a more aggressive age of fleet requirement, or they may ask you to take on responsibility for things like GPS or routing software or things like that. And I think that's the sort of thing you need to be aware of. That's the relevant current events. Some additional current events is the current state of seatbelts. Right now, there are 11 states that have state laws requiring seatbelts, and those laws come in a variety of types. Some of them actually require 3-point seatbelts. Some of them require that the contractor make sure that the student is wearing the seatbelts, but it's kind of a mishmash of states and initiatives out there. We track this frequently, and we'll talk a little bit more about how that's evolving as well. One of the other, again, current status of school bus laws is the mishmash of laws that are out there across the country about school bus illegal passing. And as you can see, there's a variety of different laws out there that require various levels of penalties if someone does pass a school bus. And what that's created really is a little bit of a drumbeat at the national level for some consistency. And that's part of the idea behind the Stop for School Buses Act that Representative Wolarski is promoting at the federal level. Some of the additional things that are affecting school bus contractors and how this is all evolving is there are currently 15 pending federal bills that would effectively affect the school bus operators. 6 of those 15 deal with technology on school buses. And you can see that breaks down into 4 pending bills that deal with safety, 2 that deal with environmental. The safety acts, and we'll talk about these in a little more detail, in some situations could add as much as $20,000 to $40,000 to the cost of a new bus. So when you're looking at things like age of fleet, and a school district is looking to get a newer fleet by making those requirements more aggressive, you need to look at that against not only what it costs to buy a school bus today, but what it could potentially cost to buy a school bus if some of this legislation is passed. Similarly, the environmental laws that are out there are often looking to reduce carbon emissions and things of that sort, and again, are likely going to increase the cost of new school buses. 2 of the 15 pending federal bills deal with insurance. Right now, the limits that they are looking to put in place mostly deal with the trucking industry, but we watch those closely. There are 2 pending federal bills dealing with grants and grant availability. One of them is DERA and the DERA Reauthorization and Funding Acts, and also one that competes with DERA, Renewing America's Schools Act. Now, the reason I say it competes is that it looks to secure funds primarily for electric buses, that's zero-emission buses. Now, that's not a bad thing unless the funding money is taken from DERA, which is primarily funding everything. It's both new diesel replacing old diesel, propane replacing diesel, and also electric. So if we take some of that DERA money and we pigeonhole it for electric, that could really make less funds available for cleaner, newer diesel motors, which, as we know, the cost of an electric bus is about 3 times the cost of a conventionally fueled bus, diesel, gas, or propane. And while that's admirable, the operating costs are much lower, the acquisition costs are much higher. 2 of the 15 pending federal bills deal with drivers. The Vibrant Economy Act establishes a 21-year-old apprentice program for interstate travel. Now, this is primarily, again, affecting trucking. Right now, you cannot cross state lines with a CDL if you are under 21, but it looks to create an apprentice program that would hopefully address the shortage, but that's, again, primarily affecting truckers. I think when we did the last research, it was 5% or less of the average school bus fleet crosses state lines. The other one is the Red Flag Act, and that is advocating an employer notification system, which basically would provide notice to employers if their drivers were to get a violation, say on a weekend or a holiday or something like that, an out-of-work violation or other violations. There are some states that actually have employer notification systems in place by operation of state regulation or state law. New York is one of them. Talking with the New York contractors, they love it. They love it because they get a report every morning, and if they have a driver that had a bad weekend and we need to know about that, you don't have to rely on that driver coming to you. You get the report. 2 of the pending bills deal with appropriations, and that is the 2 that you see listed there, and that's simply funding. And the reason we watch those is very often parts of some of the smaller bills that are out there get slid into appropriations bills, so we need to kind of watch who's on the committee and what their interests are. And finally, one of the 15 deals with illegal passing, and that's the Stop for School Buses Act. That is sponsored by Representative Walorski in the House, and it was actually launched in conjunction with efforts by NSTA. So the language in that bill is very, very reasonable. It does not create mandates, and it does look for studies to validate that what they do come up with, if they did create mandates or mandate certain things, that it's proven to be effective. The other thing that it does is that it looks to strengthen the penalties and assure that the penalties are actually enforced if someone is caught illegally passing a bus. By a little way of background, Walorski is from the state of Indiana or Illinois, where the 3 children were struck by a passing motorist. The 3 children were killed. That was in 2018, and that's a lot of her motivation for pursuing that. Some of the pending state bills that are out there that we're watching, we're currently looking at 219 bills from 35 states that could affect school bus contractors, and they break out the way that you're looking at on the screen here. You can see that the most common topic of state legislation deals with illegal passing. That's 53 of them, about a quarter, followed by seatbelts on school bus equipment, CDL licensing issues, background checks, things like that. By way of activity, consistently, New Jersey and New York are the most active states for state legislation affecting school bus contractors. New Jersey has 44 pending bills. And again, a lot of that spiked after the Paramus, New Jersey accidents in 2018, where students were killed in a bus that was trying to cross the highway. So again, the leading states are consistently New Jersey, New York, Massachusetts, Virginia. The leading issues: illegal passing, seatbelts, technology, fleet issues, CDLs, background checks, in that order there. So the current state is what we just kind of ran through. So what we'd like to look at now is really kind of the evolving school bus industry environment. And these are the laws that are either have happened or are happening in the past year. And in Pennsylvania, one of the biggest ones I think that we've been dealing with in contracts and in contract negotiations is the flexible instruction days. And a lot of people are familiar with this. In July of 2019, Governor Wolf signed Senate Bill 440, and that allows school districts to put up to 5 flexible instruction days in their calendar in place of face-to-face classroom time. So what that means is that if a snow day is looming, and we now can kind of predict the weather pretty well in advance, so a school can have a plan in place approved by the State Department of Education saying that instead of holding face-to-face school that day, they will allow the students to learn from home. And that might be an internet link, it might be taking work home, any combination of things. The plans have to be approved. And I know many, many school districts have filed plans that have been approved. And increasingly, flexible instruction days are addressed in contracts. So if you are negotiating a renewal or extension, or if you are putting together a proposal, you'll want to address that in your contracts. And that can be done a number of ways. You might require 180 days of minimum revenue days, whether or not you drive 180 or not. Very often schools will push back on that. So what we recommend is that as a fallback position, you consider a portion of your normal revenue. So while you may not have to pay wages for those days for your drivers, and perhaps don't have to pay fuel for that day, you do still have to pay for insurance. You have to pay for the lease or the interest costs on the fleet that you're financing. You need to still heat your school bus facilities, pay your office staff. There are ongoing expenses, insurance, things of that sort that go on. So what we have been successful in doing in some situations is saying, well, okay, for those days that you call flexible instruction days, you still agree to pay X percentage of the normal daily cost of the transportation because that's our ongoing costs. So that's, again, an issue that you should be familiar with. Legal Focus is the articles that you see in the newsletter every month. Article number 145 deals with this topic. So if you can't dig it out, you call the PSBA office and they'll be happy to give you that article. One of the other things evolving in Pennsylvania is the Pennsylvania Clean Slate Law. This was enacted in June of 2019, and it requires the automatic sealing of criminal records of certain individuals for certain crimes. Now, these are generally I'll call them lesser serious crimes. And the thing to remember for school bus operators is that it does not affect the information that you get on an FBI, that is federal, FBI criminal background check. So you may see situations where a report that comes back to you from the state level is different from the report that comes back from the FBI. The importance, too, is that you may have some jobs that are not subject to the same kind of background checks, whether it's a mechanic or an office staff or something of that sort. Not anything you really need to know or do other than be aware that it is out there. If you need more information on that, article number 146 from back issues of the PSBA newsletter will tell you lots more about that as well. One of the other things that we track very closely is federal regulations, and specifically federal regulations that will affect school bus contractors. Now, the thing to remember here is that even though this is something that happens in Washington, it is something that every operator in every state has to require with because it is a federal requirement. Of the 10 comments that were filed, and that is filed by the National School Transportation Association, these comments, 8 of them, were filed with the Federal Motor Carrier Safety Administration. Now, to give you a little bit of background, there's a document called the Federal Register that is published on a daily basis. And the Federal Register is where the federal agencies publish their notices of rulemaking or changes or information or requests. To give you an idea of the scope of that, the Federal Register by page count on an annual basis is usually about 160,000 pages. So we actually have software that goes through the Federal Register looking for things like school bus or wages or pupils or students or things of that sort. So FMCSA had either new rules or information requests or requests for input on things like insurance verification, hours of service, the SMS safety measurement system, all of the things that you see here. I can give you a little bit of a rundown. The insurance verification comments related to the requirement that you show that you are adequately insured. And the idea there is that's something that we would generally support, because if you are operating a bus, you should be adequately insured, and you should be proud and happy to show that. In fact, that requirement would keep out the riffraff that might operate without the appropriate insurances in place. For hours of service, there's a pending plan to increase the hours of service on the short haul exemption and related things for the activity runs and things like that from 12 hours to 14 hours, and to expand the scope up to 150 miles. So again, that lessening of that restriction is something we support, especially as it relates to activity runs that your driver might be required to do after an AM and a PM run. Regarding the safety measurement system, there is some proposals to eliminate unavoidable accidents from your count. So if your bus is rear-ended or something of that sort, this is not something that would factor into online counts of accidents. Regarding CDL knowledge testing, proposals are out there to allow testing from the knowledge portion from adjoining states, and again, anything that lowers the difficulty of getting a CDL, we support that so long as it does not compromise safety. Regarding automated driving systems, consistently we are providing feedback that any automated driving system should not eliminate a driver on a school bus. We believe that the nature of a school transportation will always require a driver. And we also want to make sure that automated driving systems that are put in place on other vehicles, whether it's personal cars or trucks or things of that sort, must be able to recognize the unique stopping patterns of school buses and respond appropriately. Regarding entry-level driver training, we are basically filing comments there. As you know, there is pending delays of the entry-level driving rule piecemeal, and we've basically said that it shouldn't be delayed piecemeal, it should be delayed completely. So we'll talk more about that in subsequent slides. As far as the P endorsement on empty buses, currently there is a requirement that you have a P endorsement for transportation of an empty bus, whether it's shuttling between locations or a mechanic driving it for test driving. And we joined in with the manufacturers who were advocating that they should eliminate the requirement of a P endorsement for the transportation of an empty bus, either for delivery after purchase, shuttling between locations, or inspection mechanic issues, things of that sort. Some of the other requirements and things that are up there, we have two comments that were filed with the National Highway Traffic Safety Administration, one on automated driving systems, which is basically the same comments we talked about. The other was seatbelt warning systems. And this was the National Highway Traffic Safety Administration exploring whether or not they should include seatbelt warnings on those school vehicles that already require seatbelts, the smaller buses. We advocated against the requirement of seatbelt warnings because, again, the seatbelts are there in those states that have them. Some do require notice that the contractor or the operator require use of them. Most do not. But the idea of kids being able to unbuckle their seatbelt and make a buzzer go off sounds like a new way to torture drivers. But in any case, we did file comments that were vetted by the organization before they were filed as well. Some of the other changes at the federal level that will affect you in your day-to-day operations is the Fair Labor Standards Act overtime rule changes. And if you remember, this is changes that have been kicking around since the Obama administration. Back in the Obama administration days, there was a very, very aggressive proposal to increase the threshold and change the rules that would expand the number of people that are eligible for overtime. It was subject of an injunction and later allowed, later dismissed. So it is back, and it has now gone into law effective January 1 of 2020. It updates the overtime rules for exempt, non-exempt employees, and it changes the overtime threshold. It is now 50% higher. Previously, the threshold had been $23,660. That's $455 per week. The new threshold is $684 per week. That means if you have someone that was being paid that $500 per week or more than the $455 amount, you really need to run them through this analysis, the three-part test for exemption. And if they are paid on a salary basis, they are below the salary threshold, and their job duties are what you look at to determine if they are appropriately excluded from overtime. And if they're not appropriately excluded from overtime, you must be paying them time and a half for any hours they work over 40. Now, it's something far more complicated than we can talk about in a couple minutes on a slide. What I recommend is that you do that analysis, and if you need some guidance on how to do that analysis or some assistance, I really recommend you give us a call. We can certainly help you through that. In some situations, we can answer your questions and you can do the review yourself. In other situations, we recommend that we kind of assist you a little bit more directly, and we can talk about that and see what's right for your organization. There is a legal focus article out there. It's article number 71.3. So if you want to get started, that'd be a great way. If you're not sure exactly what to do, ask for article 71.3, and that'd be a great way to start with that issue. Also at the federal level, FMCSA, Drug and Alcohol Clearinghouse. This went into effect on January 6th of 2020, and as most of you know, the website kind of crashed and burned. Most people were not able to register, were not able to get on. When they called the telephone numbers for help, they were not able to get answers. So what we recommend is that you keep good track of your efforts to comply so that you can demonstrate your efforts, even though you haven't been able to register and do what you need to do. Right now, employers are required to register in the online FMCSA clearinghouse, required to report drug and alcohol violations into that clearinghouse, and to conduct queries through the clearinghouse on a periodic basis, as well as upon hire. Again, I realize that you can't do that because the system doesn't work. So do follow the procedures you followed previously, but also document your efforts to comply. Legal Focus article number 148 will tell you more about the Drug and Alcohol Clearinghouse. So again, that's a good spot to start if you're looking to for more information on that. In 2020, FMCSA also increased the frequency of random drug testing. Going into effect on January 1 of 2020, the minimum annual percentage for random drug and alcohol testing has been increased from 25% to 50% for CDL drivers. Most people will ascribe to a third-party provider service that will give them the random testing candidates. They should certainly be well aware of that. But you should notice that they're sending you twice as many candidates as they used to. If you do this yourself, just be aware that 50% is the threshold. In both situations, we always recommend that operators over-test for this percentage. I've had situations where people have gotten jammed up, operators have gotten jammed up because they were under-testing because certain of their drivers were perhaps not eligible. Had a situation where a CDL holder who was either a staff member or I think it was a staff member had allowed their CDL to lapse, but they were really never called on to drive, and but they continued to stay in the pool. So while they were being tested, they were not actually a valid test, so they were tagged for under testing because these tests weren't counted. So again, be aware of the change, be sure to comply. This was discussed in newsletters in 2019 as well as member bulletins. So again, if you need a copy of that, the PSBA office would be happy to help you with that. One of the big things out there is the entry-level driver training rule. Now, the ELDT rule has been final since December of 2016. It provides a training provider registry, and it has back to behind the wheel and knowledge instructions that must be provided by a registered provider, and the curriculum standards have increased. It was supposed to be effective February 7th of 2020. However, in October at the NASDIPS conference, the FMCSA speaker informally announced that the implementation would be delayed by 2 years. However, it has not been officially announced in the Federal Register yet. I really do believe it will be moved forward. I think right now the fact that they're struggling with the Drug and Alcohol Clearinghouse would tell me that they're probably not in a great position to launch another new online application until they get the Drug and Alcohol Clearinghouse squared away. So that being said, we're watching the Federal Register for that notice, but I also let you know that they're pretty short on the notices. In fact, that increase of the drug and alcohol testing frequency that went into effect on January 1st was actually announced in the Federal Register on December 27th. That's the Friday before the New Year's holiday. So I wouldn't expect a lot of advance notice from FMCSA on these things here. So stay tuned on that, and we'll be sure to tell you what's happening as well. So one of the other big things that will be affecting school bus operators is the evolving seatbelt and technology laws. Now, again, we talked about it a little bit when we talked about all pending federal legislation, but I put it here because it has the potential to be a disruptive force in the industry. And the big reason is that the safety technology bills could add as much as $20,000 to $40,000 to the cost of a new school bus. So what this means is that you've got to look at the age of fleet terms and the contract viability, and you've got to plan accordingly. If the cost of new buses goes up because of that, you can rest assured the cost of used buses is going to go up too. At the same time, you're going to see schools pushing for newer buses that have all of these great safety technologies. Stay current with podcasts, member bulletins, newsletters. Promote the STOP Act for school buses. Illegal passing, again, is the biggest risk to students. So you've got to really watch that and promote it. You can join advocacy efforts at home. I know PSBA is going to Harrisburg at the state level, but be aware these things are pending at the federal level. So while your state legislators certainly are sympathetic, the people that we need to convince are the people in Washington, D.C. And your best route to have your voice heard in Washington, D.C. right now is through the national. In Washington in April 21 to 23, we're going to be going to Washington with the NSTA. So we really suggest that you be aware of that. If you can attend in person, that is best. They will match you up with your legislators from your local area. If you can attend, there are ways that you can do so from your location, from your garage location, by boosting the bus in to reach out to your local legislators and that sort of thing. Now, be aware that these two pending, the School Bus Safety Act and the Secures Act, don't just require seatbelts, but it is a laundry list of 9 separate mandates, things like stability control, automatic braking, fire retardant seats, every bell and whistle of a safety nature that you could imagine is supposed to be mandated. The reason that this has legs is that the sponsoring representative, Duckworth, is also one of the big 4 on appropriation bills that are working their way through Congress right now. And as I mentioned before, the propensity is to take pieces of favorite legislation and put it into these appropriation bills. And we fear that's going to happen. So we really recommend you stay in tune to what's happening there. School bus only CDL. This is an initiative that's being taken up by right now 10 state school bus associations as well as the national. And the idea is to address the driver shortage by removing CDL testing barriers for new school bus drivers and to help retain existing drivers. The idea is that FMCSA should permit the state DMVs to eliminate the under the hood testing requirement for school bus drivers. We have found that school bus operators say that appears to be a deterrent. Otherwise, willing candidates are intimidated by the under the hood portion and often drop out at that point. So the supporting details are this. The pre-trip vehicle inspection skills testing of this section of the federal regulations requires inspection of the engine compartment, allegedly because you need to do that on a pre-trip. But as you know, the pre-trip inspection requirements of this other section of the federal regulations does not require inspection of the engine compartment as part of your pre-trip. So the CDL test for school bus drivers should not include the under the hood testing because it is not required by the pre-trip requirements. Additional support, school bus is already the safest vehicle on the road according to the National Highway Traffic Safety Administration. Pre-trip inspections are performed at least twice a day on most school buses that are on the road AM, PM. Most states also have annual or semi-annual safety inspections of school buses. School bus routes are also normally 30 to 40 minutes within the garage facility that has spare vehicles. And students are your first consideration if you are a driver. School bus drivers are not expected to evaluate under the hood mechanical problems. So while a requirement for under the hood may be appropriate for long distance truck drivers who are away from their garage and on their own, it's really not something that we see as being appropriate for school bus drivers. So if a school bus driver gets their license in that manner, we're okay with them being limited to driving just school bus. And if they want to test fully, they can test fully as well. So we've got about 15 minutes to go. So I'd like to also talk a little bit about some of the court opinions that have been related to school bus operations. Some of these are Pennsylvania, some of these are other states. But we'll talk about those and then maybe have a little bit of time for questions after. One of the most current and I think most relevant Pennsylvania cases that's out there is an unreported case of Elizabeth Forward School District versus Pennsylvania Coach Lines. It's pending out in Allegheny County, and it is actually an ongoing case, but all of this is in the public record. And if you're so inclined as to read the court filings, you can read everything there. So the facts and the status is that contractor has a contract that is set to expire at the end of the 18-19 school year. On October 10 of 18, the contractor sends a letter to the school, confirms agreed extension terms. On October 17, the school board actually signs the extension on agreed terms, and transportation continues. Now, be aware that I'm relaying this from what is filed in the public record, and I recognize that in any dispute, there's always two sides to the argument. So I'm not advocating for one side or the other. I'm telling you what the public record says. On June of 2019, the drivers for this contractor are asked to sign a non-compete agreement that limits their ability to drive after they would leave the company within a period of 1 year and a range of 25 miles. Personally, I don't really believe that the circumstances of this would be enforceable, but this sets the stage for the dispute. So they got to terms in October. The school board agreed to those terms and signed a document, a contract, and the driver seems, pretty clear that they intend to go forward. However, July 31 of 2019, the contractor sends a letter to the school saying that the contractor never signed the contract that was signed by the school board and will not provide transportation in the coming year. Now, the significance here is that school is starting, so obviously they're in a bad shape. So on October 16, the school files suit looking for an injunction to enforce the implied contract. And on August 20, that's 2 days before the start of school, And this is the result of meetings with the judge and things of that sort. The contractor signs a consent order, and I put that in quotes because when you go into a judge's chamber and the judge says, I think you should do this, it's called a consent order, but it doesn't feel very consensual often. In any case, they signed a consent order agreeing to provide transportation to the best of its abilities. Now, again, I don't know the particular ins and outs here. I don't know if the issue was motivated by difficulties getting drivers or expenses. I really don't know, but that's the background. On October 25, after briefs and a hearing, the court formally granted an injunction forcing the contractor to provide transportation while litigation is pending. Now, this is currently on appeal to the Commonwealth Court, and there's also a contempt of court motion pending that was filed in December. But I think the important thing here, and why we're talking about it, is this is really the first time I've seen a court enter an affirmative order forcing a contractor to provide transportation. Now, the interesting thing is I went out and looked to see if it's happening elsewhere, and lo and behold, it is. There's a New York case, East Rampo School District, and this was decided in November of 2019, and it's very, very similar facts. Here, the contractor has provided transportation by contract to the school for 20 plus years. In February of 2019, the parties sign a contract amendment that says the school will, quote, make every effort to pay invoices within 30 days. Now, that tells me that they must have not been paying their invoices promptly, and the contractor had just about had it. Now, consider that language. Making every effort to pay your bill doesn't mean you're actually going to do it. Now, hey, I tried, and that's all I promised to do. So that's relevant because on August 9th, 2 weeks before the start of school, the contractor sends a letter to the school district giving 2 days notice of termination because the school had failed to pay their invoices within 30 days. So the court had hearings. The school filed a complaint seeking a preliminary injunction to force the contractor to provide transportation, and the court held that the injunction must be granted, that is, the buses must run, in order to avoid irreparable harm to the school and the students. Now, if you read the actual opinion, they really fixated on the language of what they agreed to. And what they said was that to agree to make every effort to pay invoices is not the same as agreeing to actually pay invoices. So the reason I mention this is I know a lot of contractors struggle to get paid timely, and I've seen efforts like this at amendment, and what I recommend is that if you're not being paid, you really need to stand your ground, and that's something that is case by case. It's like poker or jousting or something of that sort. But we really recommend that you reach out for some guidance. We're helping a number of contractors navigate this, hopefully in a way that does not end with them being forced by a court to provide transportation when you're not being paid. It's a new world, not only in Pennsylvania, but in other parts of the country as well. Some of the other cases out there, social media / driver termination. Social media seems to be the bane of school bus operators because everybody's on it and it's so easy to get sideways. So the facts of this case from Connecticut is that a contract with the school includes the school's right to demand termination of the contractor's employee for due and sufficient cause. A driver puts a post on an incumbent state legislator's campaign site that was critical of a school board member who was running against the incumbent state legislator. And granted, the post was a little edgy, but it was clearly not during work hours, not related to work. She didn't identify her employer, but she simply went on as a matter of being a citizen that votes in support of this particular incumbent and against the school board member. So the school board, on action of that candidate member, demanded the employee's termination, and the contractor complied. It was a matter of contract. The employee filed suit against the school board and against the candidate. And interesting, ultimately not against the contractor that terminated them. I have to imagine they probably had a good relationship. And what happened here is the court held that the employee's post was protected First Amendment speech, and the board's action was retaliation for protected speech. So the idea here is that the candidate and the school board will be responsible for damages for taking retaliation against this driver. And again, there's variations of this story over and over and over, and they always turn on the facts and the timing. So if you're in that situation, give us a call. Two other cases, student discipline. This one out of New York. Video confirms a disruptive student is the aggressor on a school bus. Principal tells the parent it would be best for the student not to take the bus for a while. Offers to assign an aide. Asks for notice of when the student will return to the bus. The parent files suit saying the school is denying a free and appropriate public education and on other multiple grounds. During the hearing and the discovery, the parent admits that the student was not actually barred from the bus, but the parent didn't want to take an aide because they feared the student would be ridiculed by others. Ultimately, the case was dismissed on the school's request for summary judgment, with the court noting that the student was offered transportation options that the parent did not accept. And I think the important part here is when you're faced with one of these either aggressive students or troublesome situations, your ability to offer options is very, very important. And it might be that you're offering options that you know the school or the parent is not going to accept, but it is far better to say, well, here are your options, than to say, we won't transport this student. And again, if you're in that situation, we can certainly help you through that. One other, this one out of New York regarding student discipline. A 6-year-old nonverbal student with various disabilities has an IEP that requires a minibus. Due to the school's error, the student is rostered on a big bus. Now, the school bus operator simply gets a list that shows codes, big bus, small bus. So for 6 weeks, the student is on a big bus. The student is disruptive, often strips naked. The driver files 9 incident reports in 6 weeks, and the student is finally moved to a minibus and is then more under control. Suit filed by the parents claims statutory claims, ADA, Rehab Act, 504, negligence. The lower court dismissed all of those claims that were based in discrimination because it was clear that it was administrative errors that caused the misrostering, not an intentional act of discrimination. Now, the Supreme Court reinstated the statutory claims against the school only because they felt that facts had to be taken. But the negligence claims against all parties remained, including the negligence claim against the contractor. Now, that doesn't mean that you're tagged, but the important part is it is negligence, it is covered by an insurance policy, and you will get a defense for that. So again, here the school operator did the right thing. They're going to be covered by insurance and get defense from their insurance company. So I think that's important. This is the last case I have to talk about, and it's actually a sales tax school bus operations case out of Washington State. And here, the tax rate for business and occupation tax is 1.8%, while public utility tax is 0.6%. Contractor requested to be taxed at the lower PUC rate. That was denied. After an administrative letter ruling, refund request, and an administrative appeal, the dispute moved to the court, with the contractor arguing that student transportation is for hire and should be subject to the public utility tax. Now, the reason I highlight that is that usually we're arguing just the opposite. You know, we're not for hire. We're contracted to the school district, and usually that is an argument that favors us. Here it didn't. This last point on this last case slide is that the Washington State Supreme Court held that the word for hire was ambiguous, but they looked at other states. In other words, what do school bus operators and operations that are being decided by courts do in other states? And they determined that the school bus contractor was not for hire because the contractor was paid by the school, not by the passengers, and for other reasons. But the important thing I put here is very often when we talk at various parts of the country, A contractor may say, well, why do I care about what a judge in New York or Connecticut or Washington or Florida says about, cases? Well, school bus, as you know, is a unique discipline. And even state judges recognize that it is unique to school bus and that the common thread of operating school bus in these various states is what binds them together. So while it may seem far-flung, the fact that it deals with the same business that you're in is something that you should be mindful of, even if it's not in your backyard, because it can be. So what else is out there? Want more? There are lots of resources available. We've got R.C. Kelly Law Associates. As you know, that's our firm, and you can reach us there. We've got a robust list of articles on the legal focus on school bus. And if you don't have the time to look through there, either call our office or call PSBA, and we can say, yeah, we got a couple articles on that. We'll send them to you. You can contact the Pennsylvania School Bus Association. Mike Burke is always delighted to help you, as is Christina. And they can answer a lot of questions on their own. And if it's something that they think needs a little extra handling, you can get to us. And as you know, you're working with R.C. Kelly Law Associates as part of your member benefit. And we're lonely here, so give us a call. In addition, a lot of these things come from the federal government in Washington. And the National School Transportation Association is a spectacular resource for that kind of stuff. They're available. They have also a counterpart to Mike and Christina that can help you with things that are at the federal level. And they also have a library of their own resources as well. So like I said, we've got PSBA, Legal Focus, R.C. Kelly, NSTA. The world is your oyster. Mike, is there anybody with questions out there or any questions you might have?
Yep. So, okay, I do have one question that's already been posed to us. And if anyone else has any questions, again, feel free to send them our way. Question I've got, Rich, is how concerned should I be when I don't get the contracts I have signed back from the district? Sometimes we don't get them. Apparently that's happening this year with this contractor. They still do not have them in their hand. They do pay the contracts on time, but they get a little nervous without the contract in their possession.
That's a real good question. And in fact, I can go back to the case that we talked about from Pennsylvania, the very first one. There's a theory in all states, but it's also in Pennsylvania, that is called implied in fact contract. And that's point number 6 on your screen. So in this case, it was the school saying that they had an implied in fact contract, meaning we exchanged documents. There was clearly an agreement because they're paying me according to the documents we exchanged. And the mere fact that there's not ink on paper does not mean that we don't have an agreement. Now, the difficulty with it is, okay, your terms might say for the next 5 years. So while it will usually assure that you get paid for the service that you did, it might not assure that you're going to actually have the 5-year term that they promised you. And that was probably the basis of your bargain. I'll do it at this rate as long as I have it for 5 years or whatever. So I would respectfully press them for that. And there are some ways that you can do it effectively without upsetting the apple cart. And I'd be happy to talk with you on that if you've got offline. What else we got, Mike?
Okay. That's the only other question I have up here. Does anyone else have any questions they want to throw up on the screen at this point? You cover just about everything, I think. I mean, that's amazing. I think as Rich said, obviously, if you have any questions, you can certainly contact his office directly. We take a lot of member calls throughout the week from folks on a variety of issues, and some of which get forwarded over to Rich's office. And he and Matt and Sandy are always there to help us out. And again, what we would remind everybody is March 17th, we're doing a legislative day. We're going to be watching the governor's budget address in February, on February 4th. And then March 17th, we're up at the Capitol to hopefully talk about some issues that are important to our industry. There's a lot more detail coming forward to everybody later this month or in early February. On the federal issues that Rich talked about, again, obviously watch for any updates as well from us on the member bulletin side. We've been trying to keep everybody updated on the clearinghouse issues. And we are also we're working with NST, and we're also watching the Federal Register for the entry-level driver training. I can tell you this morning there was nothing in there yet. So, again, feel free to be in touch if you have any questions on any of those. I did get a request for this PowerPoint presentation, Rich. You usually make that available to us as a handout that we can send, correct?
I'll send that over to you, Mike, and you can post it wherever that is. And in fact, I think if I am remembering, the staff here after these webinars posts it to the RC Kelly website / that was great. That's Grace's idea, but I like it.
I love it. Yeah.
And if you're looking for it and you can't find it, certainly either call the office here or call or email the office that's on your screen to help@rckelly.com, and we'll send you a link or a copy.
Yeah, we usually post it as well, as you were just saying.
Good.
Once we post the recording of the webinar, which is on the members only section of the website, we usually post the handouts along with the link to the recording. So again, you're going to have the world's your oyster. You have multiple locations to find it, but if you have any questions, any issues, just let us know. I'm going to do one last call for any other questions. Rich, you've left them all speechless. Again, a tremendous presentation with a lot of great information. And we really appreciate everybody being on this webinar. Once again, watch for information coming out in the next week or so on our February 20th webinar on workers' compensation. And without any other questions coming up, we'll thank everybody. We wish you all a great day, a safe day, and we'll all talk with you soon. Thanks again for being here. Rich, thank you so much for presenting.
Thanks, Mike and Christina. Take care.
Okay, thank you all. Have a great day.